All right, so let's dive in. I'm sure all of you are have spent the morning trying to figure out exactly what the new eviction moratorium says and what impact it will have on residential evictions here in Nevada, as we have here at Legal Aid Center of Southern Nevada. I think all of you are probably familiar with the CDC order and the moratorium that is already in place. The new Nevada statewide moratorium that Governor Sisolak issued is in a couple of really important ways very similar to the CDC moratorium that is already effective. The first important way is that it only applies to certain tenants. So, unlike previous eviction moratoriums that the governor issued, this one is not automatic. Only certain people qualify for its protections. The criteria is essentially the same criteria as under the CDC moratorium. So the person has to be unable to pay rent due to some COVID-related reason. They have to make less than $99,000 per year in 2020, and they have to be at risk of homelessness or potentially forced into a group living situation if they are evicted. So those are the qualifications that a tenant needs to meet in order to qualify for protections under this order. So the second really important way that the new Nevada moratorium is like the CDC moratorium is you have to take some action. The tenant has to take some action to get the moratorium's protections. So, like the CDC order, a tenant needs to fill out a declaration attesting that they are eligible under the criteria, and they need to give that signed declaration to their landlord. Now, so if the tenant does give the signed declaration and is eligible, the protections under the new moratorium are actually fairly broad. It would prevent most evictions through the end of March, through March 31st. So why the new moratorium if the CDC is already in place? Well, two big reasons, I think. One, it extends the moratorium that's already in place. The CDC moratorium is slated to expire December 31st. The new Nevada moratorium is extended to March 31st. The second big reason I think that this is a very good thing is the CDC moratorium was intended to apply nationwide. So because of that, its terms were actually fairly general. The new Nevada moratorium, on the other hand, is much more Nevada specific. It really relates to Nevada's eviction procedure and eviction laws, which will hopefully provide a lot more clarity to landlords and to judges so that they can tell with more certainty what evictions are precluded under this order. Now, so the message that we are really trying to convey to tenants is, one, if you have not given a CDC declaration to your landlord and you are eligible to do so, please sign the declaration and give it to your landlord. There is no downside to doing this, and there are no time frames in which you have to do it. So the sooner you do it, the better. Obviously, the tenants should keep a copy for themselves, and they should keep some proof of how the declaration was delivered to their landlord. But again, there is no downside to this. The second thing we really want to convey is this. Even if a tenant has given the CDC declaration to their landlord, if the tenant gets some kind of eviction notice from their landlord, they still need to respond to that eviction notice by filing with the court. Their declaration will be evidence in that eviction case that they are eligible for the protections of not only the CDC moratorium, but now Nevada's new moratorium. But the only way the court is going to know that is if the tenant responds. So number one, give the CDC declaration. Number two, if you get an eviction notice, respond. Number three, there is still money available for rental assistance. So if a tenant needs help and has not already applied for rental assistance, they absolutely should still apply to the Clark County Rental Assistance Program, CHAPS, and see if they are eligible to get that assistance. The big question that we have been receiving from tenants this morning is, if I've already given my landlord a CDC declaration, do I now need to give another declaration under Nevada's new moratorium? The answer is no. The directive from the governor specifically says that if you have given a CDC declaration to your landlord, that declaration qualifies you for protection under this new Nevada moratorium. So if you've already done it, you don't need to do it again. But if you haven't done it and you qualify for the protection, absolutely give the declaration to your landlord. So that's broadly the contours of the new eviction moratorium in a very quick rundown. So now I'm happy to answer any questions that anybody might have about the new moratorium. You can either unmute yourself or feel free to just type it in the chat box and we'll try to get back to you.
Hello, this is Michael Lyle, Nevada Current. Can you hear me?
Hi, Michael. How are you?
I'm doing well. How about yourself, Jim?
Well, thanks. Nice to talk to you.
So I was wondering, the CDC order has been loosely interpreted by judges, and some have still granted evictions. Some have actually been reversed by the district court, but some have just granted evictions despite tenants giving their declaration. I guess how is this gonna prevent that from continue to happening? Like if a tenant gives the new directive or gives the new declaration papers, I guess, do you foresee another problem with judges kind of loosely interpreting the directive or granting eviction still?
Hopefully not. So that's sort of what I was referring to earlier. The CDC moratorium, the order that the CDC issued, was pretty vague. It left itself open to a lot of different interpretations. And some judges were interpreting that order, the protections that it provided, pretty narrowly. The good thing about the new directive from the governor is it is really specific about what the moratorium applies to and what evictions are allowed under the order, under the directive, and what evictions are potentially allowed under the directive. So I am hopeful that will give a lot more guidance, a lot more certainty to landlords as they move forward and decide whether or not they are allowed to evict, and to judges who are faced with trying to interpret this. I think the language of the new directive 036, is actually pretty clear. So I am hopeful that we won't see the evictions going forward like we did before.
Hi there, Jim. This is Jeremy Chen with 13 Action News. I had a quick question regarding a situation with a specific tenant, but what's the legality of landlords just refusing rental assistance despite the fact that the tenant has already done all the declarations, has received the rental assistance from Clark County, but the landlord apparently is refusing to accept this money that they're getting from the county?
So that's a great question, Jeremy. And we have heard that this is happening. We've talked to tenants who have applied for rental assistance and their landlords are refusing to take it. And we don't know why that's happening, frankly. It would seem that a landlord would be eager to get that money from the CHAPS program or from whatever rental assistance program the tenant's able to tap into. Now, from a legal, I apologize. From legally speaking, there is nothing to compel the landlord to take that money. Now, the way the eviction process works, if a tenant receives a notice that they have not paid their rent, they receive a 7-day non-payment eviction notice. During that 7-day period of that notice, the landlord has to take the money if the tenant offers it. After the 7-day notice runs, the landlord really is under no obligation to take the money anymore. So most of the situations we have seen, unfortunately, did not occur during that 7-day period. It was after the 7-day notice period had run where the tenant got the award of the money and the landlord was refusing it. I think it's a really unfortunate situation given the current climate and the situation that tenants are in and the situation that landlords are in. It kind of boggles my mind that that's happening, but we are seeing it, as you apparently are as well.
Thank you.
Any other questions?
I did have one more follow-up. Sorry, go ahead.
Yeah, sorry. This is lortlieb with Fox 5.
Hi, Lee.
How's it going? So, real quick, I have a two-part question. If you can kind of clarify and walk through what the steps are that the residents need to take in order to get these protections, and this is in regards to like filling out the new form and what they need to do with it. And then the second part of the question is, what do you guys, after the form has been filled out and everything, what do you guys do in conjunction with the courts to handle the eviction notice?
All right, so first part of the question, what does a tenant need to do to get the protections of the moratorium? So what the tenant needs to do is they have to first evaluate whether or not they qualify for the moratorium's protections. Are they unable to pay rent because of COVID? Do they make less than $99,000 in 2020? And are they likely to be rendered homeless or forced into some type of group living situation if they are evicted? So tenant first evaluates whether or not they're eligible for the protections. If they are eligible for the protections, then the tenant signs the CDC declaration. Now, the governor issued another form declaration with the directive that he issued. Right now, tenants can absolutely go ahead and continue using the CDC declaration. There is no reason to switch and start using any other declaration. The CDC declaration is widely available. It's been translated into numerous languages. It's easily accessed on multiple websites, including Legal Aid Center's website. So tenants can fill out, print that CDC declaration, sign it, give it to their landlord. They need to keep proof that they provided it to their landlord. That can be an email, it can be a certificate of mailing, and they need to make sure to keep a copy for themselves. That's what a tenant needs to do. Now, as far as what we, Legal Aid Center, is doing, we are trying to help as many tenants as we possibly can. As you probably expected, our calls to the center, to Legal Aid Center for assistance have skyrocketed. So if a tenant needs assistance, they can absolutely call us. They can call our, they can call our hotline and an advocate will answer the phone and try to give them whatever assistance they possibly can. If it is something that we can take on representation, we may even have, if we have the capacity to do that, we may even be able to assist with the preparation of the legal documents or even representation in court if necessary. Now, hopefully with the new moratorium, all of that will die down. Hopefully evictions will stop or stop to a great extent, and everyone can focus their attention elsewhere for a little bit, at least until March 31st.
Hi, Jim. This is Christine. We have a question posted in chat from Bert Johnson with KNPR. He asks, could landlords be refusing CHAP payments so they can turn occupied units over with higher rents? I understand this might require a little speculation, on your part, but is there anything you have heard about that?
So it's possible. We have heard at least 2 instances where we know that landlords have refused CHAP payments because of the tax implications, which would lead me to believe that the landlords apparently were not claiming the income from the rental properties and felt like they would now be forced to claim that income. So we have heard of those situations. It's possible that the landlord thinks they will be able to, if they can evict the tenant, then they may be able to re-rent the property at a higher amount. I think that is risky from a landlord's perspective, given that there are thousands of people in town who cannot rent right now, who have no money. So I don't know what's going to happen with the rental market and whether that's a realistic strategy, but potentially that's a reason. I honestly don't know.
Thanks, Jim. I think we have time for 1 or 2 more questions, and then I will wrap it up with a reminder of how people can connect with Legal Aid Center of Southern Nevada. Are there any final questions?
Yeah, this is Alexis Goree with News 3. Hi, Jim.
Hi, Alexis. How are you?
I'm doing well. So I have a question kind of in the realm of what you've been talking about. When it comes, you say that calls for assistance have skyrocketed. How are you guiding tenants through, say, landlords who are bad players? Is there any advice you can give here?
So a little bit. So obviously all of the normal landlord-tenant protections still apply. So if a landlord, for example, has locked a tenant out, that is absolutely against Nevada law, and there is some action that the tenant can take. They can file a motion with the court and try to get back in the property on an expedited basis. So there are some protections built into Nevada law. As far as violations of the moratorium, under the initial statewide moratorium, the AG, the Attorney General's office, was very active in trying to police that moratorium. If there was a complaint made to them that a landlord was violating some protection included within the governor's directive, the Attorney General would reach out to that landlord and try to rectify that situation. And we heard really good reports from tenants that that was in fact happening. So luckily, the new moratorium under Directive 036 that the governor just issued similarly makes a violation of the directive an unfair business practice that would allow the Attorney General to do some type of enforcement. So if a tenant if a tenant has a landlord who is violating the moratorium in some way, they should absolutely make a complaint to the Attorney General. They can also contact our office, and we will assist them with submitting that complaint if they need that help, and we will evaluate what other action could potentially be taken to assist that tenant.
Okay, thank you.
Sure, of course.
So I don't see that we have any further questions, and it looks like we're about ready to wrap it up as far as our time frame. So I just want to thank you all for joining us today at this briefing, and please stay tuned to our social media channels for updates. We're on Facebook, Twitter, Instagram, and YouTube, as well as check our website periodically. We will be updating our legal and financial toolkit with this information that you can share with your viewers, and that's on our COVID-19 resource page. Thanks again.
Thank you, everybody.